I mean, I know that the solutions have been there because there has been a recent media exchange between law bodies and the Chief Justice. I want to understand a diagnosis of the problem. What actually happens? An application comes in, why is it not decided timelessly?
Commissioner, look, we are balancing many things. So let's say you have a hearing the next day. You are the final court of appeal. A matter comes in. You need to give serious attention to both the hearing that is the next day, and then you need to ensure that you fully understand what the issues are in the leave to appeal application. You not only have to understand what the issues are, you need to go and research the law relating it to see whether or not the SCA or the High Court or whichever other court it's come from, whether that law is correct. You then need to prepare a memorandum, and then you need to ensure that 8 other colleagues agree with what you've said, which of course also is difficult because there are lots of, there may be disagreements as well on that, on the question of whether to grant leave to appeal. And that's just one leave to appeal. We've now got 400 almost, if you think about it, in the year. And so therefore you've got these, you're trying to balance on the one hand the leave to appeal applications that are coming in with at the same time writing judgments, having hearings, and ensuring that you engage deeply with the law, as I've said, is required to ensure authoritative, clear, and quality judgments from the Constitutional Court. And so I think that what we see is that that exponential increase has placed a huge burden on individual judges, and that therefore we have to grapple with how to address the solution and the institutional solutions, that 2 of which I've suggested.
Just for the last one, Chief Justice, and what have you found yourself as I'm still trying to get a practical understanding of this. The reason I ask is because, I was also asked by Nadel, to look at that issue around the appointment of additional judges, let's put it like that, to help the Concord. But I was still not understanding what exactly is the problem. You see, for instance, in the SCA, they decide 1,000 applications for leave to appeal per annum, and they achieve a 96% decision rate. And they give much more judgments per annum than the Constitutional Court does, and within a short space of time. So I was trying to understand, if we are to be constructive, where exactly are we going to say the problem is? I mean, from your experience, have you written a note? So you get an application for leave, you've been allocated, you write a note to other judges. And what happens to it? Where does it get stuck in the system?
It's not a question of getting stuck, I think, Commissioner. I think it's a question of having the time to consider properly. Remember, this, as I've mentioned, the Constitutional Court is the final stage. So when you dismiss an application, that is the end of the matter. And so one needs to spend and apply one's mind with great diligence to when one refuses leave to appeal. And as I understand it, the difference between the SCA and the Constitutional Court is that the SCA, the matters are decided in panels of 2. And that allows for much speedier decision making, and it allows things to take place very quickly. Where you have a panel of at least 8, and of course we were sitting last term with 10 judges, so all 10 judges are going to have a say on the matter. Each one of those judges needs to apply their mind to the matter on top of all the additional matters, and of course we each are writing our own new apps, plus other judges are writing their own new apps. And so it seems to me that the delay is inevitable when you have a system that is requiring at least 8 judges to agree with or dismiss a leave to appeal. And so I think the solution is, as I've suggested, reducing the panels and potentially having assistance to the judges with experienced lawyers who can help sift through those issues and do that research that I was talking about, so that we make the right decisions and that we hear the matters that must be heard and that are absolute imperatives to hear, but we also don't hear matters that don't deserve to be heard by the Constitutional Court.
Good afternoon, Professor Wiltshire.
Commissioner.
Earlier, and I thought I misheard you earlier, but I think you've just repeated it now. When you were asked this question around 174.5, and why, in your view, academics are, in your words, best placed to assist the Constitutional Court, you raised 3 factors. You spoke about the range of exposure to other jurisdictions, which I think you particularly have. You spoke about academics engaging with younger people, and you spoke about what you called the depth of engagement, and that's getting into deeper underlying issues. Now, I just want to check, you're not suggesting that the non-academic candidates for this position, including very highly experienced judges, highly experienced practitioners, are not able to meet these three criteria?
Commissioner, I think I was trying to underline not to indicate what others don't have, but what academics have to bring. Academic expertise is not exactly the same as other forms of expertise. I think that is very important to assert. It's a different form of expertise. I could have chosen to go a route of being an attorney or an advocate and be appointed as a judge potentially, and that would have been a different route of a legal career. An academic career brings with it certain advantages and disadvantages. And no doubt colleagues who have, as we know, we've got very experienced judges, we have very experienced advocates who are before you, and they have incredible expertise and would be incredible appointments to the Constitutional Court. But they don't have the same expertise as myself. And the key is to distinguish, and that's what I suggested to you, it's distinguishing the difference between the expertise, right? And I think that's what I was trying to grapple with and develop as an argument of what can an academic particularly bring.
And that's exactly what I'm probing with you, Professor Bolchich, is this so-called point of distinction. What I'm putting to you is, and you drew it again in your answer earlier to JP Mlambo, you drew a distinction between what you call deep substantive knowledge and deep procedural knowledge. And what I'm putting to you is that that distinction is illusory. Given the kind of candidates we have before us, we've got highly experienced judges who've practiced in other jurisdictions, who've got that deep knowledge of the Constitution. We've got extremely experienced practitioners who have experience on the bench and in practice, who clearly have a strong academic background, and therefore also have that deep understanding of the Constitution. So what I'm probing is what you seem to be putting forward as a distinguishing factor, which clearly doesn't seem to be the case.
I disagree with you. I don't think, and I'm not seeking to, as I say, cast any aspersions on any other candidate. But there is a difference between people who spend their life researching and working on issues around fundamental rights and people who take particular cases, and I'm not knocking this expertise, but try and marshal the evidence for their clients as far as possible to deal with to give the best possible case for their client. And I have noticed in the Constitutional Court, from my own experience, that now, having acted, that there is in fact a lack of depth at times in the submissions that are put forward, and a lack of the ability to engage with those deeper, substantive, underlying questions that relate to what conception of privacy are you engaging with? What approach towards socioeconomic rights are you dealing with? How do you justify some of the elements? The issues remain at a particular level of doctrinal engagement. And I'm not saying we have incredibly smart, brilliant people who are also candidates. Their experience differs from people who spend their days working and researching around both comparative law, both the substantive and philosophical dimensions of law. And I have seen that in my personal experience, that I've had something to give to other colleagues and they've had something to give to me. And so I think it's really important to recognize that individuals who, there are some here, brilliant individuals who have written books, for example, as well, and who've spent the time of research, and they will perhaps attest to the difference between writing a book and writing a brief before the Constitutional Court. There is a difference, and I've tried to capture that through that reference to the depth, to the ability to connect different ideas, to explore and excavate the underpinning philosophical justifications underlying that, to make connections that you don't necessarily need to make. And perhaps one element is the imagination, the constitutional imagination that an academic can do without working within the four walls of the particular system itself. And I think that's an important distinction, that one is working often as an advocate within the system, in a lower court, often with the precedent that comes down at you, but without having to actually develop and suggest what is the best way in which the law can build, can be realized. And that's what academics do. They spend, or the academics who's similar to me, how do we best give effect to certain of the deeper values of the Constitution in particular areas? I hope I've tried to convince you of that.
Not necessarily, but let me put my last concern to you, talking about working within the four corners and working within the rules. You've spent a lot of time today trying to persuade us that your viewpoint on the core minimum content is in fact the correct one. But we know that the Constitutional Court has repeatedly indicated that it does not rely on core minimum content, and it does opt for what you call the reasonableness approach. And in very well reasoned judgments, repeatedly. You accept that the die is cast as things stand, and that you work within those parameters if you get to the Constitutional Court.
I think the answer is a complex one. The first one, and I think that is a big difference, as you've said, is that the role of precedent as a judge is much more powerful. And one can't simply come into a court and overturn a long history of development because you have a different theory or you think your theory is better. And so I think that respect for precedent is an essential element. And I think, as I said, this is one of the distinguishing features of academia, being able to stand outside the box and actually say, what are the problems with the routes that we've gone down? And academics doing that, but then with your hat as a judge, needing to respect the precedent and not overturning and creating continual revolutions in the law. And so there's a balance, right, that's going to be achieved, that needs to be achieved between, on the one hand, recognizing, and the Constitutional Court itself has, right, I'll point out, for example, recent example, the Bwania case, which overturned the case of Fawkes versus Robinson, which was widely criticized in the academic community, and the Constitutional Court overturned that case. It is possible to overturn, for the highest court to see that it's going down a route that is not a productive route or not one that achieves justice. On the other hand, one could strengthen and improve existing jurisprudence so that perhaps something like reasonableness takes account of some of the critiques without jettisoning the precedent that's involved and that the court has developed. And so my role as a judge would be to give due regard to precedent, not just to impose my theories that come and that I've engaged with in terms of thinking about how best the law could be, but to also inform how we develop the law. And that's the key issue at the constitutional level, is that the law is not totally fixed. And how do we develop substantive law in this country, that it achieves the goals of our constitution and substantive justice for all South Africans?
Thank you.
Thank you very much.
I just
Commissioner Nochesi,
Thank you.
can I move on?
Is it Commissioner Noches?
Maybe
I
if
think
there's time.
he will allow me to step in.
Commissioner Nochesi, to give up your time to Commissioner Bajobi?
No, you will have his time.
Commissioner Nochesi, okay.
Yeah. Good afternoon, Prof.
Good afternoon, Commissioner.
Prof, I only have two questions. First, you admittedly say you are only an expert in constitutional law, and all your Articles 27, they are on socio-economic rights. That's what you have written about, mainly. Now, in fact, you written on constitutional law, let me put it that way. The comments in recent years has been that the depth of judgments coming from the Constitutional Court, in particular in the area of private law, needed to be balanced. And you seem to bring nothing in that area. There's simply no value that we are bringing. Secondly, you only acted, as it has been said, for 2 months. I'm not too sure whether it's 2 months. No judgment you have written at all, not a single judgment, where we can objectively assess you, other than your own promises that, look, I'm fine, and then all that. And lastly, you say, in terms of section 174.5, well, academics must go, must be there, which is correct. But I'm not too sure whether your interpretation of that section is correct. That you take any academic, you ignore all the other considerations. What objective evidence do we have that if we are appointed to the Constitutional Court, you will be able to hit the ground? As we know now, we are not an all-rounded judge. We are only somebody who specializes in constitution. If you can answer, I would request you, Prof, so that we move faster. We don't get, and this question has been debated, but I just want to get, some Africans there are watching. Here's a judge who has not a single judgment. What is justification for your appointment, other than to say there's section 174.5?
I would suggest to you the record of my writing and what I've been involved with is what you would need to assess in relation to whether I'm able to do so. I suggest that there are quite a lot of similarities between, they're not exactly the same, but between academic writing and judge making. You need to marshal a lot of evidence. You need to listen and engage with different points of view. You need to be able to structure an argument, and you need to be able to provide a point of view. And I would suggest to you that those are, I cannot, as I've said to you, point to a judgment, but I can point to what my writing says. And I would also just like to suggest that my record isn't only on socioeconomic rights. I hope I didn't give that sense. I've written on business and human rights. I've written on LGBTQ human rights. I've written environmental rights and animal rights. I've written on limitation of rights. No. So I've written on a lot of things, and also on areas of private law.
Sorry, Prof, I understand. Your answer is that we must look on the articles. That's the answer to what my question was.
That would be the evidence of what that you have.
The second question, the ICJ in 2004, specifically it's 9 July, that is 2004, on a pertinent question about Israel and Palestine. Make this on a pertinent, this is a decision of that court, and this is a finding they make. I want just to read one sentence for you. The court concluded that the construction of the wall, along with measures taken previously, severely impeded the exercise by the Palestinian people of its right to self-determination, and was thus a breach of Israel's obligation to respect that right. This conclusion had followed a finding that the creation of this wall was tantamount to a de facto annexation. That is 2004. Now, come 2019, you write an article. Your article which says creating a different future for Israel and Palestinians. Are you aware of that? You remember that article?
Yes, I do. Thank you.
I want us to talk briefly on that. And correct me if I'm wrong. The impression I get from the article is two. First, you criticize the comparison of the actions by the Israel government with those.
Sorry, Commissioner Nojesi, I assume that that's an article that's in the bundle.
Yes, yes.
Okay.
That's an article. Yes, that's
Okay.
an article. In fact,
Chief Justice, I'm not sure if it's in the bundle, but I just want to put on record that we did give Professor Bulchitz notice that questions will be asked about his article.
Okay, no, that's all right then. Thank you.
now, in the article, in parts, this is what you say. You say, this is what, this is an observation. You criticize the comparison of the actions by the Israel government with those of apartheid South Africa. You describe the comparison as nonsense if one considered the different origins of the conflict. Were you aware of this decision of the ICJ of 2004? Because in the judgment, you simply make not even a single reference to it.
Commissioner, I'm very willing to answer questions about issues and my prior writings relating to Israel-Palestine. I would, though, like a direction from the Chief Justice if this is appropriate for me to do so. I am aware that the former Chief Justice was disciplined by the Judicial Conduct Committee for expressing views relating to the Israeli-Palestinian conflict. And I am currently a sitting judge of the Constitutional Court, and I've taken the view, ever since I knew I was an acting judge, I have expressed no view on any conflict that involves foreign policy, that involves the domain of the executive, and I've tried to conduct myself in that way. I am very happy to defend what I said and what my views are, but I'm also not sure that I'm entitled to do so. So I will ask for direction from the Chief Justice in that regard, and if I'm permitted to answer your question, I will do so.
Yeah. No, just before the Chief Justice answers, I'm asking this question based on your article in 2019, in view of the judgment of the ICJ, of which the starting point was to establish if you were aware of that judgment of the ICJ when you were writing this article.
Absolutely.
If we can agree on that.
And I would suggest to you, just in very broad terms, that my general record in regard to writings on Israel-Palestine, and I don't think that is at all different from that article, is that I accept international law and I seek to give effect to international law in everything I've written in relation to Israel-Palestine, to defend the rights.
Professor Vilches, you wanted me to give guidance. You have started giving an answer before I could say anything. Well, one, I thought that at least the question that had been asked to you was simply limited to whether at the time of writing the article you were aware of the judgment, which didn't seem to me should create any problem. But to the extent that there might be another question that you might be uncomfortable responding to without guidance, then one could take it from there. But the one about whether you were aware or not didn't seem me to be problematic.
Absolutely. As someone writing in the area, Chief Justice, I'm very aware of that judgment, and I would suggest to you that the article is in fact completely in accordance with that judgment by highlighting the various injustices in relation to the military occupation of occupied Palestinian territory in that article that I seek to draw attention to.
Yeah. Lastly on this, but if you don't want to, if you are not comfortable to answer, you can say so. The immediate impression in the article you wrote in 2019 is that, in your view, Israel is not a colonial settler. That is the view that I make. Is that fair?
To answer your question, would it be to wade into a highly contested engagement with issues of history and politics, which I think would be inappropriate for me as a sitting constitutional court judge to answer. I would just make the point that my record in this regard is to, one, defend the role of international law and try and ensure that it is given effect to. Two, to defend the rights of human rights of Israelis and Palestinians, and to try and utilize the South African experience to try and understand how one brings people together from very, very, very different histories and narratives to find some kind of resolution and negotiated settlement. That has been the impetus of my work in that area, and I would suggest to you my work has tried to give effect to the values of our Constitution and broaden that in international.
Don't go too far, Professor Vilches, if you say you are uncomfortable. If you go too far, you may be opening yourself up for further questions.
Thank you, Chief Justice.
Yeah, this is the last third question. These two is that were taking long. This is a third
I want
question.
to make a
Short.
follow-up. I want to make a follow-up on the question before you go to the third one.
The one that is uncomfortable to answer?
Yeah.
And then he will say if he's uncomfortable with your one too.
No, I'm just saying the question is based on the article he wrote.
Yeah.
And we're saying to him, we're putting it to him, that it will be our interpretation that you are saying Israel is not an colonial occupier. And if he says, I'm not going to comment on that, that remains our opinion and it will be raised in deliberations.
Well, maybe what we should do is excuse the candidate briefly and let's talk among ourselves. Is it fine? Let's just do that before we proceed. You'll be called back, Professor Pilchitz, and will the media also please excuse themselves and other people. Welcome back, Prof.
Thank you, Chief Justice.
Thank you. We have had a discussion, and the position is that you are being asked questions about a view you expressed some time back, and not as a judge. And clarification is being sought so that it can be determined how, what weight should be attached to that view for if any, for purposes of deliberations. And it's fair that you be given an opportunity to clarify. So, but if you are not comfortable to answer, you won't be forced to answer. But the commissioners who may have sought clarification would then deal with the matter without the benefit of your clarification. Okay, all right, thank you. Now, Commissioner Malema, you wanted to follow up, or you wanted that question. That's when we excuse the candidate. I think I must give you a chance to ask your question.
No, Chief Justice, I was not asking a question. I was just repeating what Commissioner Nonchesi said, and he
okay.
said
Yeah.
it's uncomfortable responding to that. So I was saying to him,
Yes.
if that is the stance, it means in the deliberations,
Yeah.
I will be allowed to express that view as a correct view because you didn't put a counter argument or seek to clarify it.
Yes.
Thanks.
No, thank you, Commissioner Malema. Just to make sure that we are on the same page, Commissioner Nojesi, do you want to put that question again to the candidate so that he can then now answer if he is comfortable or to answer, but also knowing what the consequences will be if he doesn't answer, namely that commissioners would look at the matter, consider the matter without the benefit of his clarification.
Thank you, CJ. What I was saying to you, Prof, is this. The total impression of that article is that you suggest that Israel is not a colonial settler in Palestine. I mean, is not an occupying state. That is the total sum of what one gets.
As I've mentioned, I do not want to wade into a matter that is of deep controversy at the moment in the South African community. I would hope people who are Zionist or anti-Zionist or post-Zionist would have faith in me to address issues if they ever come before the Constitutional Court in an impartial manner. I would suggest to you, the only point I'd like to make in relation to the article is that when I brought a delegation from Myanmar, I engaged with some of the senior members of the ANC who negotiated South Africa's settlement. And they said to me, despite not seeing any justice in what the Nationalist Party had to say, they tried to think themselves into the perspective of those who they had to negotiate with and tried to understand what is the deepest fears they have and how can we find a way through that. And I would suggest to you that my work, and that article in particular, is an attempt to say where there are deep divisions, contesting narratives, which are really landing up in an absolutely horrific situation we all watch at the moment, an Armageddon. How can we find a way through? How can we listen to each other and our different stories that we have around Israel and Palestine to find a way that the people of that area can share the land and share a future together? That's what I've sought to do. I've tried to be a peace builder in my work. I've tried to engage with peace in Colombia, which is a place which...
Sorry, Prof, you have answered my question.
Thank you.
Mr. Chair, I think I should end here.
Sorry, Commissioner Jesse.
I think in view of time, I must stop here. Other commissioner will follow. Thank you.
Just a follow-up, CJ.
Okay, thank you.
CJ, follow-up.
Oh, Commissioner Malema?
Yeah, mine is very simple, Prof. Do you still stand by that article?
Mr. Malema, I'm not sure I would write every single phrase in the way I did. I shift my own views as well. But in large part, the necessity to find a way through, to understand the two very divergent and competing narratives, and to find a way for the two peoples to listen to each other and to live together in peace and dignity with respect for self-determination and international law, those are all things I would still stand by.
Prof, do you still stand by that article? Because it can't be, you can't have it both. It's either you say there are parts of the article that, given the new information exposed to me, I will rather not keep in that article. So if you stand by it, just say so. So when I leave here, I know Prof still stands by that, or there are these other parts which, with more information and hindsight, is no longer standing with those.
Commissioner, I stand by the thrust of the article, as I've said to you. I think there are changed. We had seen differences over the last 5 years. We have also seen there are currently, and it's not right for me to express an opinion about proceedings before the International Court of Justice at the moment on a number of questions. And as I said, as someone deeply committed to international law, I would also see myself as bound to shift my views if the International Court of Justice finds in certain ways that require me to shift my view. But as I say, I'm not able to express my view on those things. That's inappropriate for a judge sitting in the Constitutional Court at the moment to express views on proceedings currently in an international court. And those may have caused some change to some elements of the article. But the thrust for need for finding a way through to peace, I stand by.
Sorry, Chief Justice. Sorry to interrupt, but
Commissioner
Professor
Maitomi.
Bilchis, when I first raised my hand 3 hands ago, I wanted to ask you a question about contract, but I'm now going to ask you a question about this thing that's being debated. The reason is because, I always watch candidates here before the JSC. They are asked a relatively inane, mundane question. They complicate their lives, by appearing to be defensive or evasive, etc. Now, I'm afraid that is the impression I'm getting around this issue. And, and it's not a complicated question. You wrote an article and you said you don't buy the story of apartheid, you don't buy the story of colonialism, right? That's fine. We can have debates about that, and apartheid is an international legal issue. And occupation is also an international legal issue. We don't need the views of our top judges in the Constitutional Court on these questions, because South Africa is engaged in the international space. and it has been engaged since 1994. It can't avoid it. So this idea that, you say, well, there are certain things have moved along, it gives the impression that you are evading the issue. So
Commissioner, I
never
think that's
understand.
really unfair. There is currently, as you know and you have argued, there's a case currently before the international.
Hang on, Prof. Hang on. When Commissioner Toby says this to you, to say what you are, the way you are responding gives the impression that you are avoiding. It's to your benefit, because he wants to give you a chance to say to him, no, I'm not avoiding, and here is why you shouldn't think I'm avoiding. You persuade him. So he's giving you that benefit. If you don't explain that, he's going to go into deliberations with the picture that you are avoiding. So he's trying to make sure that he's fair to you.
Thank
Okay,
you,
all
Chief
right.
Justice, and I
Okay.
apologize if I appear evasive. I do not want to be evasive in any way. I do not see it, and I take that view as appropriate for me to express a view on proceedings. There's currently proceedings relating, which South Africa has brought, relating to genocide before the International Commission of Justice, and there's also an advisory opinion that has been requested on questions around occupation and apartheid. I see it as inappropriate for me to answer questions about whether or not this is correct when South Africa has a live case and live interest in that, and the principles are being discussed at that level. As an academic, I would love to do that. I'm not currently just before you as an academic. I'm before you as a candidate for the Constitutional Court and acting as well on the Constitutional Court. And so,
No, Professor Pilches, I'm sorry. I think that the problem that I'm grappling with, you were not here when we had a break, but Commissioner Malema made an example and said, if you just asked JP Mlambo, what do you think about Israel versus Palestine? Without anything, he would be entitled to say, I've not actually formulated views. In fact, I'm very surprised that you're asking me that question. Can I please get a pass? But he was saying, what is different with you is that you have, in fact, written an article, right? And you have expressed these views. And so many things have happened. And we just want to get a sense that, all right, this is the view you expressed, this is the view that you take. And that's the only context in which I said, should I not be worried that you are evasive? Because this is not something that you are being asked for the first time. You have written about it. So is this the view now that you carry with you in the Constitutional Court as a future judge? And these things are actually very simple. No one is trying to catch you. In fact, personally, I'm actually I was looking forward to this interview. And I thought this question could be dealt with within a minute.
well, I'm not sure how I can deal with the question in a minute, but Commissioner, as I've said, I'm not trying to be evasive. I've made perspectives in the past. I have expressed where I stand in the past on these things. At the moment, since I was appointed as an acting judge, I have not commented on the last 6 months of horrific events that have taken place in the Middle East, and I've said nothing for exactly the reason that I believe it would be inappropriate for me to wade into that territory, and that people in South Africa with vastly different points of view should be able to have confidence in me, and that I will fairly, and I think the key thing that needs to be understood is my commitment to fundamental rights. I've defended that in everything I've done. A commitment to international law, which I've defended in everything I've done, and a commitment also to finding ways through to peaceful resolutions of intractable conflicts.
Thank you very much. I think we move on. I've got 2, 4, 5. That is Commissioner Tlaba. I don't know whether Commissioner Malema is still going to want. Then Commissioner Dodovu, Commissioner Breitenbach, then Commissioner Mangena. I propose that I should not take any further hands. I should just exhaust those. Commissioner Tlaba.
Thank you very much, CJ. My questions have been exhausted. I only have one question.
Okay, thank
It's
you.
just for yes or no answer. Prof, do you hold a dual citizenship?
I am only a South African.
Thank you.
Thank you very much. Commissioner Malema?
Thank you, CJ. Just a quick one, Prof. So I think we are in agreement that you don't have experience as a judge. For the record, Prof.
That's correct. I have only been acting as a judge for the last 2
So
months.
now,
Yes.
if I'm presented with a black African male who comes with a huge experience of a judge, including good judgment writing, and Shem is at your level. It's you, except that you don't have experience, but also this judge, because I don't buy this thing that only academics can write very well. So for you to be a good writer of judgment, you must be an academic. We've been having very good judges writing very good judgments, and they are not academics. So then through the judgments of this judge, you can see that it's very good. So when you are confronted with that kind of a situation, what do you do?
Thank you, Commissioner Malema. The
In
key
line with transformation, yes.
Yes, absolutely. The key provision is Section 1742 of the Constitution, as I'm sure you're aware, which says the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered. In light of our history in South Africa, it is an imperative to have racial and gender transformation. And so I would think there would be a degree of preference towards the black male candidate or black female candidate even higher in many ways. What I can offer is as I've mentioned, a diversity of perspectives, and also perhaps one element of diversity that hasn't really been canvassed thus far. And that is that when I was growing up, people with my sexual orientation were criminalized for having same-sex relationships. And during my lifetime, the Constitution has fundamentally changed my life and that of others in the LGBTQ community, first by decriminalizing our sexuality, and then recognizing our rights to stand shoulder to shoulder with other South Africans in dignity. There are still very few openly LGBTQ judges in South Africa and in fact around the world. And I remember how deeply moving for me it was to see the first Constitutional Court judge, Justice Cameron, appointed to the court. Why is it so important? Because I think when we look at Section 1742, we want South Africans to see themselves in the court. And so I would hope that my appointment would in some sense advance LGBTQ representation and also perhaps serve as an indicator to the young lesbian woman I met last year from Katlehong and the transgender activist who I met who was rejected by their religious community, whose families have refused to accept them and for whom they've been rejected, and who opened up to me about their own pain, that the South African legal and political community seeks to embrace people with diverse sexual orientations, and that she and they and others like them, whoever they are and wish to be, can be authentic in their own identities. And so I would suggest to you that there may be other elements of identity, such as sexual orientation, such as disability, which may play a role in the deliberations of this commission.
Last one, CJ. I'm a very, supporter of LGBTQ community. I'm the only president of a political party who marched to Uganda wearing a rainbow flag, because that is a community that I feel very strong. It needs to be supported. You have all what it takes, Prof, except this fundamental issue of experience. And you just joined a church. And then after joining the church, the next thing you're asking is, where are the pastors sitting? Just on arrival. Don't you think that is unheard of?
Commissioner Malema, you point out, of course, my lack of judicial experience, but I am an experienced professor. I am still young, like yourself as a political leader, and I think we're a young country in many ways. We also have a young Minister of Justice and many young people who committed to advancing this country in the different ways that we have to do that. I agree with you. I lack that experience, but I have a different experience, as I've suggested, which is what I need to be considered on the basis of. So it's not something that I can say to you. I can manufacture judicial experience that I don't have. That's something I don't have, but I do have all these other things. And if you think the things that I have can enhance the Constitutional Court, then that's the way in which I put myself forward for the court on the basis of what I do have. Thank you.
I'm very sorry to do this, CJ, too, but why can't you?
Or
Because
maybe Commissioner Malema, because I wanted to say something about the question you put to him. If I can just say something before you continue.
but maybe before you say that, so that you can enrich what I'm
Okay,
going to say.
Okay.
Why can't you just say, okay, this is my weakness. Let me go and work on it. And we ask Chief Justice, I don't know who else, the powers that be, to give you more acting stints. And you just said you are young. There are people who self-disrupt. Don't self-disrupt. You are young. There's nothing against you except this element which is workable. You go and work on it, and then you perfect it, and then come back here. And your interview is going to last for less than 30 minutes when you come back, because we've asked you everything. But you say, if this is a fair criticism, I accept. Let me go and accumulate more judicial experience. Thanks.
Commissioner Malema, that is one possible route, and of course, that is one possible way that my career could unfold. My caution about that route is what it does is it requires, in a way, it says to academics, your only route to the judiciary is in a way by shifting your career from academia into the judiciary. And in a way, already my university is required to find replacements for me and has been very, very kind, the University of Johannesburg, and always very supportive. But what it does mean is that the academic loses their academic dimension and becomes more of a judicial figure, and then only can get appointed. And I think part of what I've suggested is that if you want that fresh academic perspective, in a sense, partly outside the judiciary, then it's possible that it's not a weakness that one doesn't have judicial experience. One just brings something different to the experience of being a judge. Thank you.
Well, I wanted to say, Commissioner Malema and Professor Vilches, that Professor Vilches chose not to say to Commissioner Malema, you see, Commissioner Malema, I was at the university going on with my business, never thinking about acting in the Constitutional Court until the Chief Justice phoned me. and when he phoned me, he said, the only people he would give an acting appointment if they were academics and senior practitioners would be people who would commit themselves to making themselves available. That's why I'm here, So I just want to say, in part, it's the Chief Justice who has encouraged them to make themselves come forward, make themselves available. Of course, that doesn't necessarily mean that if necessary, further acting stints can't be given. But I'm just saying the context is that they were minding their own business until the Chief Justice phoned them. Okay, thank you.
Thank you, Chief Justice, for sharing.
Thank you. Commissioner Dodovu.
Thank you, Chief Justice. Good afternoon, Prof.
Good afternoon, Commissioner.
It has been a long session for you. Now, on your own accord and evolution, you gave some practical examples of how the Hood bomb case was handled. And you said to us that you were doing your clerkship at a time that the matter was heard and the judgment was delivered. I want to traverse with you on that particular case. I'm doing so because of one specific reason, and the reason is that you said, as I listened to you carefully, you were totally not satisfied about the whole judgment. Now, I know as much as you do that the matters that come before the Concord or its decisions are res judicata are binding, are final and binding, and you cannot go beyond the apex court. You know that, and I do. Now, what are your specific concerns about Groot bomb case that you would want to share with us here as a commission? And I'll make follow-up based on what your response is. Thanks.
Commissioner, the Grootboom case, which I was in fact a clerk on, was concerning for me for the approach that it adopted towards socioeconomic rights. So although actually I think it's one of the more substantive cases, if we look at in hindsight, that the court has given, the court focused a lot of its attention and its attention on the reasonableness idea. And it said that our duty as the court is to establish whether there's reasonable legislative and other measures to achieve the progressive realization of the right. And it essentially found that the failure to make provision, the government came and said, well, we have a housing program for the longer term, but it didn't make provision for people who were on a field with no roof over their head. And what the court said is that's unreasonable. And I wanted to try and understand what underlies the unreasonableness of the failure to make provision for those who lack a roof over their head. Because I found it a vague standard which doesn't really provide guidance to courts, to other branches of government, and it really removes a sense of what the content of the right is. And actually, what I think the court was saying is that there is actually a minimum requirement that you need to ensure that everyone has a roof over their head and is not in desperate circumstances. And it actually could have gone to the right itself, to Section 26(1), the right of access to adequate housing, and it needed to put a complex relationship, recognizing that reasonableness is about the legislative and other measures that to achieve the progressive realization of the right. And the court needed to say more about everyone has access to adequate housing, that adequacy at least means access to a roof over your head, basic services, etc., what the court developed. So my worry is the lack of engagement with the content of the right.
But Prof, as you know that this is a seminal judgment. It gives direction and meaning to how Section 26 of our Constitution must be implemented to ensure right to adequate housing, as you say. But equally important, it also gives effect to Section 152 of the Constitution that spells out the objectives of local government in terms of what is it that it must do. But you say you have specific issues with that. And other than saying the reasonableness that you are explaining, you don't spell out in precision what exactly do you have problems with, because this particular judgment, as seminal as it is, as landmark as it is, it has given a practical meaning in terms of forcing government to develop programs that support the poor and give the poor shelter over their heads. And I don't understand. Can you just clarify that better?
Yes.
In a way that I will understand where I see that.
So my worry, Commissioner, about reasonableness is that actually, as you've said, it actually, that judgment did have some impact on government policy in terms of the passing of an emergency housing policy. The order in that judgment was also very weak. It was a declaratory order and didn't order any particular specific things to actually occur in some ways. And one of the critiques that's been raised is that Mrs. Grootboom never actually got a house at the end of the day, and she passed away sadly without that. But my main problem relates to, and it might sound very academic, but the way of approaching socioeconomic rights. Let me try and explain to you why that's really difficult. is that what the court essentially said is, when we look at social rights, we're going to evaluate the reasonableness of a government program. And I was involved a little bit with some civil society organizations. And you need to come to court instead of simply showing, I don't have food, I don't have housing, right? Which many other jurisdictions, that's the basic. A litigant must come to court and show, I don't have adequate housing, I don't have adequate food. Instead of doing that, in South Africa, you need to show a hell of a lot of complicated things. You need to show that the government in its whole housing program is unreasonable in the way it is giving effect to those rights. And that involves evidence, it involves social science research, it involves a whole lot of aspects which make it very difficult to get access to rights that you wish to get access to.
Thank you.
Yeah.
It's okay. Thank you, CJ. I'm covered.
Thank you very much. Commissioner Breitenbach, I'm not sure whether you said you were covered earlier on.
Thank you, Chief Justice. I am covered.
Thank you very much. The last one is Commissioner Mangena.
Thank you, Chief Justice. Good afternoon, Prof.
Afternoon.
Yes. At some point, I thought I would let this question pass. But there is a nagging edge to put it to you. In my student days, I was an ardent supporter of academic freedom because I believed that academics should be free to express themselves without any form of restraint in the process of knowledge production. Now, but here's my problem. You are an academic, and in the judiciary, there is something called judicial restraint and judicial temperament. And with you seeking to sit in the Constitutional Court, where you are going to sit with about 10 or so judges, and highly opinionated as you are, you strike me as someone who's highly opinionated and believing in his. Once you believe in something, it's very difficult to let go. And that's the impression that I got since this morning. Do you think that you possess a necessary temperament and restraint to work together with other people to a point where there would not be unnecessary delay in judgment production because judges are held to, for lack of a better word, ransom in dealing with academic issues instead of legal issues? Your comment, please.
Thank you very much. I think you've put your finger on like a big difference between academic writing, as I've said, and judicial writing. Judicial writing is by its nature more restrained, more minimal in its nature. It needs to say what's necessary, the reasons that are necessary to reach a decision. Academics, as I've tried to show, go deeper. They tend to uncover various reasons, connections that you wouldn't necessarily make in a judgment. And a nice example of what you're saying is when I was a law clerk, I wrote a memorandum for Justice Langer on a matter, and he looked at it and he took a paragraph and he said, I really like this paragraph and I want this to utilize it. He said, but the rest is for your book. And I think that illustrates very nicely the distinction between the two different types of writing, that there are more constraints in judicial writing. At the same time, there are also constraints in academic writing, of course, by length and polish, etc. And you asked me, can I make the transition? I think yes, I can. I mean, I think that it obviously. There's still, as you've said, you need to still look at what comes out. But I have already acted on the Constitutional Court already now for 2 months. And I think I recognize that the roles are different whilst they're complementary. And that there's and that whilst I can bring in that depth, as I've tried to suggest, that understanding of substantive issues, I'm not going to be writing books and developing theories in judgments, which would be inappropriate to do so. So I think that there is a sort of balance that needs to be struck in some ways, but also that restraint is part of the nature of being a judge. It's a restraint that I've also tried to exercise here in some questions which have been asked to me. I was freer to say things before I'm an acting judge at the moment. And so I think that is something that, as I said, I see. I've also, I should say, written in various fora. I've written newspaper articles, blogs. I've written journal articles and books.
Try and be succinct, Prof.
Sorry, Chief Justice. I was just trying to say that I've expressed myself in different ways, and so I try and adapt my writing to the constraints of what's required by the institution.
Fair enough. My second and last question. Now, Professor, they asked you a question about section 167 sub 3. I need to ask you for your comment on 167(6) that deals with direct access.
Right.
No, don't worry about it. 167(6) gives litigants direct access to the Constitutional Court and provides for requirements, right? So it says that if you are to go directly to the Constitutional Court, there are requirements that you've got to meet, and the applicant would need to satisfy those requirements in the affidavit, right? But you need direct access to sit in the Constitutional Court, right? And you are relying on 1745?
45, yes.
Yes. Now, with 167(6), if you don't meet the requirements, that's the end of the matter, right? With 1745, what happens if you don't meet the requirements? Because you've got to be assessed on your appropriateness and fitness and the tools to help this commission, judgments, and those kind of things. How are we going to be able to assess whether you qualify for direct access?
Well, I'm a different candidate from the other candidates, and so as I've mentioned, the assessment has to take place on the basis of my record. And I suppose one of the questions for which I don't want to presume to answer, but one of the questions for the Commission is, if you consider that academics can be appointed directly to the Constitutional Court without prior judicial experience, what are the criteria we're going to use to assess those academics? And I've suggested to you that some of the reasons that I think academics may be appropriate for direct, as you say, direct access or direct appointment to the Constitutional Court. And I think one would need to assess, does the person meet those requirements? Have they got a body of work that shows the required depth, that shows the required breadth? Do they teach? Do they engage with students from a range of backgrounds? The kinds of reasons that I've suggested, these are the kinds of criteria that one would need to look at and say, well, does he meet these kinds of criteria? And because of course, it's possible the Commission will decide that that's not a possible route. But if this is a route, then there needs to be criteria. And then the question is, do I meet those various criteria as a result? Thank you.
Thank you, CJ.
Thank you very much.
CJ?
That was the last.
I just want to make a correction I thought my brother will make.
Yeah, okay.
His surname is not Mangena, it's Mangena.
Hey, thank you, Commissioner Malema. When I said it, I wanted to say I'm hoping I've got it right, because I know there's a difference. I think that
CJ,
some of us who
CJ?
come from KZN are said to pronounce it in a certain way. So I apologize. But Commissioner Malema, just say it again.
Mangena.
Mangena. Okay. Thank you. Okay,
CJ, I'm sorry. There's one adverse issue that has been raised by the law bodies that hasn't been put to Professor
Okay,
Belcher.
yes, thank you.
Professor Belcher, I think largely commissioners have put to you most of the adverse comments raised by law bodies. There is one comment that hasn't been dealt with. It was raised by Nadell. And they point out that you indicate in your application that you, according to them, appear occasionally in court, but that you are on the non-practicing role. Now, I looked at your application. I didn't see you say that you appear in court. I think you did it as a candidate attorney many years ago. But you do say in your application that you do opinion work. And I think the question is whether or not you're entitled to do that kind of work if you're on the non-practicing role.
Yeah, I said specifically that I did not appear in court, I think, in the application. So I have not violated any of the law or rules of the law. I think the key issue is I've been involved in brewing litigation. That's what I meant in engaging with, as I say, questions of socioeconomic rights, providing input to attorneys and advocates about those questions. As I understand it, there's no prohibition of an academic being engaged about their views in relation to whether a case has the prospects of success or not, and whether or not this would be a good case to put forward or not. I've also done some of that in relation to my work in relation to animals. And in fact, I'm an applicant on one case. So, but I'm not a representative. So, as far as I understand, that is not something that academics have ever been prohibited from doing. I have never sought. I initially did think I might balance an academic career with a practice career, but I realized, and apart from some very exceptional individuals, I don't think they're entirely cognate. Because I think academics need that time that I've tried to mention to develop those deeper theories and writings. And so that's the extent of the work that I've done.
Thank you, Chief Justice.
Thank you very much. Thank you very much, Prof. We have come to the end of the interview. Once again, thank you very much for availing yourself for this interview. We appreciate it. Thank you very much. You are now excused.
Thank you very much, Chief Justice, and thank you to the commissioners.
Commissioners, we are at 13 minutes to 5. We took quite long with this candidate. Earlier on, you'll recall I said I understand that we previously made a resolution that we should try and not go beyond 5 o'clock. But in terms of my own commitments that made me raise that, if we were to stop at 6, I would still be fine. So I'm raising this to say, looking at the time, do we take the next candidate? And if we take the next candidate, what are we looking at in terms of finishing?
CJ? The
Commissioner
reality
Malema?
is that we can't take an hour with a candidate. And it's always very difficult to start an interview and adjourn and come back the following day. So I think, given your pressures, we should be able to try to rearrange. I don't know, but an hour is not possible.
No, I think an hour would be difficult. Commissioner Singh?
Yeah, Chief Justice, the other challenge we'll have is if we don't complete them today, you are not here tomorrow. And
I can come to finish them. It's just that I can't be here the whole day tomorrow. So I'm hoping that we would not take too long. But we would have to, one of the candidates we will interview is a candidate that we have interviewed a number of times, Dodson. And the others are candidates who are not new to the body, but should we adjourn until tomorrow at 9, and then we'll just do the best we can? Is that fine?
CJ, I'll join
Yes.
online tomorrow.
Okay, no, that's fine. That's fine. Okay, all right. Thank you, the commissioners. We'll adjourn now and we'll resume at 9 tomorrow. Thank you.